This is Barry Zalma on insurance. Today I'd like to speak about the birth and growth of the tort of bad faith. In Fletcher versus Western Life Insurance Company, a 1970 decision of the California Court of Appeal, the plaintiff was at the time of trial a 41-year-old father of 8 children, 7 of whom were still in school. He had only a 4th grade education, and before he was disabled, was employed as a scrap operator for a rubber company, which required heavy manual labor. He earned about $289 a week, working 70 to 80 hours a week. He purchased a disability policy from Western National before his injury, which provided for payments of $150 a month should he become totally disabled because of sickness or injury. In the event of sickness, such payments were limited to a maximum period of 2 years. Fletcher was injured while lifting a 361-pound bale of rubber. Many doctors examined Fletcher and concluded he was permanently disabled. The insurer, after learning Fletcher would be disabled for his entire life, concluded he suffered from an equinic condition called cauda equina, or a horsetail-like aggravation of nerve fibers originating from the lower part of the spinal column, traveling for a short distance in the canal of the spine, and refused to pay the claim. Here the insurer was held liable for the wrongful refusal to pay claims submitted by the insured on his disability policy. For the first time, the rule imposing tort liability for the breach of a first-party claim of the insured. Remember, both Commonale and Chrissy were third-party cases. The insurer argued it had the right to negotiate with the insured to get him to accept an amount less than the insurer's potential liability. The court responded, an insurer owes to its insured an implied in law duty of good faith and fair dealing, that it will do nothing to deprive the insured of the benefit of the policy. We think that similarly the implied in law duty of good faith and fair dealing imposes upon a disability insurer a duty not to threaten to withhold or actually withhold payments maliciously and without probable cause for the purpose of injuring its insured by depriving him of the benefits of the policy. We think that, as in Chrissy, the violation of the duty sounds in tort, notwithstanding that it also constitutes a breach of contract. The Court of Appeal also said, we hold, therefore, that defendants' threatened and actual bad faith refusals to make payments under the policy, maliciously employed by defendants in concert with false and threatening communications, directed to plaintiff for the purpose of causing him to surrender his policy, or disadvantageously settle a non-existent dispute, is essentially tortuous in nature and is conduct that may legally be the basis for an action for damages for intentional infliction of emotional distress. We further hold that independent of the tort of intentional infliction of emotional distress, such conduct on the part of a disability insurer constitutes a tortious interference with a protected property interest of its insured, for which damages may be recovered to compensate for all detriment proximately resulting therefrom. The Fletcher Court also stated, defendant's conduct was premeditated, continuous, and persistent, and defendant Amason, who was still employed as Western National's claims manager at the time of trial, indicated that he would conduct himself similarly if a similar situation should again arise. The primary function of punitive damages is to deter the defendant and those similarly situated from engaging in similar tortious conduct in the future. For the insurer, the testimony of its claims manager was damning. Consider also Richardson v. Employers' Liability and Gruenberg v. Aetna, where the insured under a fire policy sought recovery against the insurer for seeking to deprive him of the benefits of the policy. Richardson, as explained by Gruenberg, opened the door to first-party property insurance bad faith. In Gruenberg, the insurer Aetna was accused of causing Mr. Gruenberg to be arrested for arson without a factual basis for the arrest. They then refused to allow Gruenberg to resolve the criminal accusation before he appeared to present his claim. The California Supreme Court found the action of the insurer wrongful, a breach of the covenant of good faith, and subjected the insurer to a trial on the issue of whether Mr. Gruenberg was entitled to punitive damages. From these few seeds, of course, grew the tort of bad faith that spread from California across most of the United States. Note that at the time Gruenberg was decided, the court had no evidence before it. The case was decided on a demur to the complaint, where the court assumes for the purpose of hearing the demur that all of the allegations of the complaint are true. After a review of Comunale, Crissy, and Fletcher, the Gruenberg court stated, quote, "It is manifest that a common legal principle underlies all of the foregoing decisions, namely, that in every insurance contract there is an implied covenant of good faith and fair dealing, and the duty to so act is imminent in the contract, whether the company is attending to the claims of third persons against the insured or the claims of the insured against itself. Accordingly, when the insurer unreasonably and in bad faith withholds payment of the claim of its insured, it is subject to liability in tort. The insurer argued that any duty it owed under the policy to its insured was dependent upon the insured's performance of his obligation under the policy to participate in post-claim examination. The court disagreed and stated, while it might be argued that defendants would be excused from their contractual duties, that is, obligation to indemnify, if the plaintiff breached his obligations under the policy, we do not think that plaintiff's alleged breach excuses defendants from their duty, implied by law, of good faith and fair dealing. In other words, the insurer's duty of good faith and fair dealing is unconditional and independent of the performance of plaintiff's contractual obligations. We conclude, therefore, that the duty of good faith and fair dealing on the part of the defendant insurance companies is an absolute one. At the same time, we do not say that the parties cannot define by the terms of the contract their respective obligations, merely that no matter how those duties are stated, the non-performance by one party of its contractual duties cannot excuse a breach of the duty of good faith and fair dealing by the other party, while the contract between them is in effect and not rescinded. The insured in Gruenberg refused to appear for an examination under oath. The law of the United States and of the state of California up to the time Gruenberg was decided was that a failure to appear for an examination under oath was a breach of a material condition of the policy that voided it. The decision was based on the law as it then existed, and the decision of the California Supreme Court in Gruenberg changed the law to the detriment of Aetna. There are a plethora of suits now naming adjusters and attorneys. Each suit alleged that the attorney and or the adjuster conspired with the insurer to violate the covenant of good faith and fair dealings or the Fair Claims Settlement Practices Acts. These suits have disappeared since the California Supreme Court concluded in Gruenberg that only parties to the insurance contract can be held for violation of the covenant of good faith and fair dealing. A majority of jurisdictions that have considered the issue hold that there must be an insurance contract between the claimant and the defendant to create a duty sufficient to maintain an action for bad faith breach of an insurance contract. If you're not a party to the contract, it's impossible to breach it. A minority of courts hold that a claim for bad faith breach of an insurance contract may be brought by or against a non-party to the insurance contract. Then came Silberg versus California Life Insurance Company, a 1974 decision of the California Supreme Court. In Silberg, the insurer advertised an accident policy with the phrase, "Protect yourself against the medical bills that can ruin you." It issued an accident policy to Mr. Silberg. The policy excluded injuries covered by workers' compensation. Silberg was injured while performing incidental services at his place of employment. His employer's compensation carrier denied coverage. Mr. Silberg found himself with substantial medical bills, which California Life also refused to pay. California Life claimed that no payments were required to be made until the question of workers' compensation coverage had been resolved. The court held that the insurer could have made the payments required under the policy, and if workers' compensation were later determined to be applicable, a lien against the award could have been filed. Even when California Life proved that withholding payment until the conclusion of the compensation coverage litigation was common and consistent with the custom in the insurance industry, it found that following such a practice did not absolve the insurer of its obligations. The scope of the duty of an insurer to deal fairly with its insured is prescribed by law and cannot be delineated entirely by customs of the insurance industry. And therefore the court concluded that under these circumstances, defendants' failure to afford relief to its insured against the very eventuality insured against by the policy amounts to a violation as a matter of law of its duty of good faith and fair dealing implied in every policy. An insurer should never leave the insured without benefits while it is involved in a dispute with another insurer or provider of benefits. It should rather protect its rights to dispute coverage and get its money back by means of a reservation of rights letter or a non-waiver agreement. The reservation of rights letter keeps the insurer, while it is taking care of the insured whose coverage is in question, from being bound to the insured forever. It allows the insurer unilaterally to give itself the opportunity to complete a thorough investigation, determine whether coverage applies, and then, if it does not apply, withdraw its benefits, and even seek return of what it has paid. The non-waiver agreement is a contract where both the insured and the insurer agree that while the insurer is investigating, neither party waives the rights available under the contract. Insurers may also use a device known as a loan receipt, where it loans the benefits to the insured without admitting liability. The insurer can recover later from the other insurer or the person responsible. Thus, both the innocent insured and the insurer are protected. Taking a technically correct position on an insurance policy without seeing the adverse effects this can bring on the insured can result in a verdict for tort damages. Many courts recommend that two insurers attempt to agree to share the costs equally and work out their differences later. If such an agreement cannot be reached, then the company you represent should front the money under a reservation of rights, take an assignment from the insured, and sue in the insured's name the other insurer for all the money paid, plus damages incurred by the insured. It is always best to work together to protect the insured while deciding who's on first, who's required to pay, and who isn't. This video was adapted from my book, Selma on Insurance Claims, Part 106, Second Edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be useful or interesting to you or your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel, and my blog and Substack publications so that you can be advised of future videos and future blog postings. If you found the video useful, please click on the like button on YouTube and the Rumble button on rumble.com. Thank you for your attention.